Good afternoon, everyone, and welcome to our webinar today on the 21st Century Cures Act, Interoperability, Information Blocking, and the ONC Health IT Certification Program Final Rule. That was a long title, but many good things included in the rule. My name is Elise Sweeney-Anthony. I am the Executive Director of the Office of Policy. Presenting with me today will be Mike Lipinski, who heads our Regulatory Affairs Division, and Mark Nee, our Senior Policy Advisor. Today, we're going to be focusing on information blocking. And as many know, we released our final rule last Monday. And since then, we've had our first overview webinar last Wednesday. This is the second webinar in our series, and we'll focus specifically on the provisions that Congress asked us to move forward from the Cures Act, so the 4004 information blocking provisions, which we've implemented in this final rule. Next slide. So there are a couple of housekeeping items that we'll mention today. First, I want folks to know that we have our next webinar. So we're beginning this one, but we're already ready for the next one. The next one will be on March 19th, and it will be at 3 p.m., and that one will focus on the conditions of certification. In addition, for those who are interested, please join us for our Health Information Technology Advisory Committee, which will be held on March 18th, and that will be from 10 a.m. to 1 p.m., and we'll be presenting on different aspects of the rule there as well. There's always an opportunity for public comment at the high-tech meeting, so please do join us. So as the second webinar, this will be a recorded webinar, and we'll have it available on our website. This webinar is designed to focus on components of 45 CFR, parts 170 and 171. And although we make every effort to make sure that the presentation is accurate, we do want to note that this is not a legal document. So as I always encourage folks to do, please do check out and read the rule. Not just the regulation text, which is also important, that regulation text, but also the preamble. And the preamble includes the comments that we received as well as our responses. So it's an important part of the rule components as well. And lastly, of course, check out our website, and we'll mention that a couple of times during this presentation, and that's at healthit.gov/curesrule, and you'll find a number of technical resources there related to the rule. This presentation, this communication, was developed at taxpayer expense, and I want to mention one other thing as well. This webinar is scheduled for 1 hour and 15 minutes. And I know that's a little bit longer than we usually do, but given the number of provisions included in the information blocking provision, we wanted to make sure we had enough time to talk about not just the 8 exceptions, but also to spend some time talking about the terms and definitions that are critical to understanding the provisions in the final rule. Next slide. So our agenda today focuses on a couple of different parts. We're going to start with some of the background, the parts that led us to the development and the finalization of the rule. Then we'll talk about the framework, the timeline, and some of the terms that attach. And lastly, to the exceptions and the complaint process. Let me start with the background. Next slide. So the path to the 21st Century Cures Act. There's many, I think, pieces to this puzzle, but in 2015, Congress asked ONC to draft a report that focused on information blocking. How is it occurring, as well as identifying some areas, some ways to address it. So we released that report in 2015, and from there, worked with Congress as they were developing the Cures Act, providing technical assistance. And ultimately, in December 2016, Congress finalized the 21st Century Cures Act, which was signed into law at that time. And that act included definitions for information blocking, as well as provisions related to how to address the practice itself. Next slide. And the path to the final rule also starts early. So when we're thinking about any rule, we start with thinking about what is happening on the ground. What is actually happening that is impeding the flow of information? How is it occurring? What are the circumstances? Who is impacted? Who are the potential actors? And who are the folks for which information is not flowing? Sometimes it's patients or someone acting on behalf of the patient, or sometimes it could be providers as well. So we wanted to hear a lot from stakeholders about what that environment was. And we did. And we heard a lot also in conjunction with the Office of the Inspector General, which you'll hear us talk a little bit about in a second, about some of the situations that individuals were seeing in terms of the practice of information blocking. So through that listening stage and understanding what was happening on the ground, we also consulted with federal agencies, from the Office of the Inspector General to the Office of Civil Rights, which manages HIPAA, to the Federal Trade Commission, and others to really understand what they were seeing as well, as they are very important players in the health IT landscape. Ultimately, we issued our proposed rule in 2019, March 2019, and we received over 2,000 comment submissions. And here's where I want to stop and say thank you, because we know the amount of work that it takes to think through and develop the comments that you are submitting to us and the time it takes to do so. And we really do appreciate that, because that helps us to get to a final rule that is addresses the policies that we need to address, but also is able to work on the ground. And that's where we ended up on March 9th, 2020, with the release of the final rule. Next slide. So before we get into the provisions of the rule itself, let's look at Section 4004, as we affectionately term it, which is the section in the Cures Act which covers information blocking. So that section gives a definition for information blocking. It also authorizes the Secretary to identify what are termed as reasonable and necessary activities that do not constitute information blocking. In other words, information blocking might have occurred, but there's a reasonable and necessary reason why it happened, why the blocking occurred. So perhaps that's for a privacy reason, or it's a security reason, or several of the other reasons we identify in the rule. But we, as on behalf of the Secretary, were tasked with helping to identify what those activities look like. In the proposed rule, we identified 7, and we ultimately landed at 8 in the final rule. And we'll walk through each of those step by step in a little bit. The Office of the Inspector General is tasked with investigating claims of information blocking, and it's an important part of what we do here. We also work in conjunction with the Office of Civil Rights. There is a complementary piece in the conditions of certification, which is the next webinar that we will do, but the conditions of certification are focused on health IT developers that are certified by ONC. And for those particular group, certified health IT developers, they also are not allowed to information block as per Congress. So there's a complementary enforcement element there as well. The rule also prescribes the penalties associated with information blocking, which we'll get into. And last, identifies a complaint process, the importance of implementing a complaint process as part of information blocking enforcement. So we'll talk about that at the end. Right now, I'm going to turn it over to Mike Lipinski for him to walk through some of the terms as well as the framework and the timeline associated with the information blocking final rule, components of the information blocking final rule, that is. Mike?
Thank you, Elise. Good afternoon, everyone. I want to first welcome back those of you that joined us last week, and also a warm welcome to those joining us for the first time today. So while I and my colleague Mark are going to discuss information blocking in more detail today than last week, the good news again is that you still don't need to take notes, because this presentation is being recorded, and the recording and the slides we're using today will be made available on ONC's website. One other important note is there may be a silence at some point. That doesn't mean that it's been disconnected. It's me probably going on mute to cough, and I thought it'd be better to not do that into the microphone today. So with that, let's jump in. So next slide. So the slide you see now may look familiar, as it's the same slide we use for the proposed rule presentations on information blocking. As an attorney, I kind of think of this as the prima facie case for info blocking, but for most of the stakeholders listening today, you should generally think of this as a checklist when it comes to information blocking. And there's been a lot of emphasis placed by stakeholders on who is an actor, the HI definition, and especially the exceptions. And I think all that is well-founded, and we address that in the final rule. But I want to just emphasize also that all these elements that you see on the screen are important, because even if an actor doesn't meet the exceptions, they may not still be an information blocker. And I say this because they may not have the requisite knowledge that their action interfered with access, exchange, or use, or their action or practice may not even rise to the level of an interference. And in a little bit, I'm going to talk more about some actions that we think do and do not constitute interferences with access, exchange, and use. But before then, let's discuss a few of the other matters related to information blocking. So next slide. So with this slide, let's talk briefly about the potential consequences one might face if the individual entity was found to be an information blocker. So as noted here, the department may levy civil monetary penalties up to $1 million per violation. And then also per statute, healthcare providers are actually not subject to those civil monetary penalties, but they're subject to appropriate disincentives. And importantly, these disincentives must be established by the Secretary through notice and comment rulemaking. And as we speak, that has not occurred. And I have no big announcements on that front either. So last, as mentioned last week in our overview presentation, health IT developers of certified health IT that violate the information blocking condition of certification may be subject to a certification ban or even the terminations of their certification for health ITs that they've. So let's move on to the next slide. So this slide, most of what you need to know is on the screen here. There's a 6-month compliance delay. This same delay applies to the information blocking condition of certification under the program. And also, importantly to note, the rule has not published yet. So the clock doesn't start until that occurs. It first goes on display at OFR, and then there's a time lag before it actually publishes. And then these compliance dates kick in. The other thing worth noting, which you see here on the screen, is OIG will not begin enforcement until there's a civil monetary penalties final rule. And so what that just means in sum is that at minimum there's at least a 6-month delay, and as noted here, may be longer. And I think the last piece of information to offer you on that point is OMB, who reviews all the rulemakings, has not concluded review on the CMP proposed rule yet. So it's still, that needs to go out there, it needs to be comment, and then OIG needs to finalize the rule. We can move to the next slide. So now on the screen you see the information blocking definition. It starts, the basis of it is in the statute, the Cures Act. As we proposed, one thing we did was we combined interfere with the terms such as materially discourage, and prevent into one term, interfere with. But more importantly, we added this new paragraph you see on the screen, which is B. And what that is, it's limiting the scope of EHI within the definition for the first 24 months. And that scope is to just the data, EHI that is identified by data elements represented in the USCDI standard. So that means from the time the rule becomes that compliance is required, and then up to another 18 months after that, the expectation is actors will provide the data that's represented in the USCDI, not the full scope of the EHI definition, which we'll also talk about more. And as you may see on the screen, in full disclosure transparency, there are some what they call in the regulatory industry technical corrections that we'll need to make for this definition. For example, as you see in paragraph 1, we used interfere with, but we repeated like to prevent and materially discourage in paragraph 2 and 3. So we'll make a correction to that. Let's move on to the next slide. Sorry. So there's certain individuals and entities identified in the Cures Act that are subject to the information blocking provision. For rulemaking purposes, we have generally referred to these individuals and entities as actors. And we have provided proposed definitions for each of them, and I'm going to go over the final definitions next, and spending the bulk of my time on the definition of for health information networks and health information exchanges. So we can move on and start doing that into the next slide. So healthcare providers, we retained the proposed definition in the final rule, which is really the same definition that Congress gave us in the Cures Act, and that definition cross-referenced the definition of healthcare providers found in the Public Health Service Act. Moving on to the next slide. Health IT developers of certified health IT. If you're interested in why we came to our decision, including how we addressed comments on our decision to focus on health IT developers of certified health IT, I recommend digging into the rule on that. There's a lot of description and response on in regard to the comments we received. But for today, I'm just going to mention a couple key factors, which are we had requested comment on self-developers, and so this definition expressly excludes them from the definition of health IT developers as certified health IT. But as a reminder, they are still developers under the program, and they would be subject to the information blocking condition of certification. Another key point is we did not extend the definition beyond the date on which a developer had or offered certified health IT under the program. So we had requested comments on that with some concern about, providers getting their data when a developer, they were going to switch developers and so forth. And we think other provisions of the rule will help address that, as well as, reminding and recommending to providers that they ensure in their contracts that they have the availability of EHI when they intend to switch EHR providers or terminate contracts. And one other thing is, I think, worth mentioning here is once you are a developer of certified health IT, that means you're subject to any information blocking claim, not just claims related to certified health IT. Moving on to the next slide. Excuse me. So with health information networks and exchanges, while keeping the functional definition, we revised the proposed definition in 4 ways. One of the biggest ways, obviously, as you see here on the screen, is we combined the definition of HIN and HIA to create one definition that applies to both statutory terms. We got a lot of comments expressing that concern regarding overlap between the definitions, and we took that to heart. And as you see here, we think this is going to be more as administratable as one definition for both terms. We also limited the types of actions that would be necessary for an entity to meet the definition. In particular, we removed substantially influence, as commenters had pointed out, that term was both broad and vague, and we obviously agreed with that in terms of removing it. Also, and a theme that you'll see here and we'll talk about more is alignment with HIPAA, in that we focus the scope of exchange on treatment, payment, and healthcare operations, as each of those terms are defined in the HIPAA rules. And again, like I said, this once again acknowledges that overlap between actors subject to information blocking that are also covered entities or business associates under the HIPAA rules. And the last key change I want to talk to you about is revise the definition so that it has to be more than 2, so essentially 3 unaffiliated entities besides the HIN or HIE themselves. In the proposed rule, we said it just had to be 2. And the other key part of that is that those entities have to be enabled to exchange with each other. And as we discussed in the rule, to be able to exchange means you have to have the ability and the discretion to exchange with each other under the policy agreements, technology, or services provided by the HIN. And essentially, what they think this revision will do, it ensures that the definition doesn't unintentionally cover what are essentially bilateral exchanges, in which like an intermediary is simply performing a service on behalf of one entity and providing the EHI to another entity or to multiple entities, and no actual exchange is occurring between all the entities involved in that. So if you had 4 providers sending to an intermediary that's standardizing it and sending it to a registry or to a reporting agency, that wouldn't necessarily be a HIN under the definition, because none of those providers are exchanging with each other through the network of the intermediary, and nor are they really exchanging on the other side, the reporting agency or the registries. So hopefully we feel this is going to be more understandable to our stakeholders and administratable. Moving on to the next slide. So let's talk about the EHI definition. As with the HIN and HIE definition, we are very cognizant of actors likely being subject to HIPAA rules as well. And so based on the proposed definition, commenters were keenly concerned about having to separate EHI from EPHI because of the broad definition that we provided for EHI. and then having that segregated data to comply with both laws. So what we've done here to address those concerns is we focus the EHI definition at this time on concepts that we believe stakeholders are used to related to the HIPAA rules, and they're widely understood in the healthcare industry. And this also focuses on a set of health information that is currently collected, maintained, and made available for access, exchange, and use by actors. Let's move to the next slide. So now I want to spend a little bit of time on one of the key elements, and that's interference, as we defined it in the regulation. So we're going to discuss a few examples on the next two slides, but I'm going to recommend that you read the section titled Practices That May Implicate the Information Blocking Provision in the information blocking part of the preamble of the final rule. And that starts on page 646, and there's more examples as well contained in there, and those examples I think start around page 658 of the version that we have up on our website. So the first one I talked to you about is pretty straightforward, FHIR endpoints. Those need to be published, otherwise they could constitute, if they weren't, a interference with access, exchange, and use, because they're key to be able to provide the connection between the apps and the API. The next one I want to talk about is delays. So we didn't establish a set time frame of what is timely access, and because obviously there's a lot of variability around that, and it's going to be based on the specific facts and circumstances. But we did acknowledge that any type of slowing or delaying of access exchanges could implicate the information blocking provision. And so when I say could, it's because we acknowledge that there are legitimate reasons to do it, but we've also seen and heard from stakeholders there are reasons where the delay is not legitimate, and they're doing it because of maybe for competitive purposes or other reasons not to provide access. And the one point I'll mention again is like how these things work together between these elements and the exceptions is that here, so maybe it is an interference from a delay, but then an exception may apply. So when I was telling you earlier, maybe you don't meet an exception, but you might not meet one of these elements. I'll give you an example of how here, where maybe it is an interference, but you have an exception. So under the Health IT performance exception, which Mark will talk to you about, we added in a provision about assured level of performance that would permit like the throttling or metering of access to limit negative impacts on the performance of Health IT. So there's a situation where it could be a slowing, but you meet an exception. So even though it was an interference, as we describe an interference. The other one I want to talk about very quickly is charging patients for electronic access. So that would be inherently suspect, and we defined electronic access in the fees exception of the final rule, and that was to mean an internet-based method that makes EHI available at the time the EHI is requested and where no manual effort is required to fulfill the request. And you'll find that definition in reg text as well. I'd also want to acknowledge we have a discussion in the final rule about vetting, and where it draws a distinction where it's acceptable, such as when there's an expectation under the HIPAA security rules for business associates, and then when generally there would not be a need for vetting, such as with patients using third-party apps that connect to certified API, which are read-only APIs that use OAuth 2 and meet other security requirements. Let's move to the next slide. So now I want to talk to you about a couple things we pointed out in the final rule that aren't an interference. So generally speaking, and this is this overarching HIPAA alignment theme, if you follow your BAA, you would not be an information blocker. It would not be an interference. However, there are two key points. One is, in relation to that, is that it has to be non-discriminatory in nature, the provisions of the agreement. And so an example of that would be, say there was a BAA entered into by one or more actors that permits access, exchange, or use of EHI by certain healthcare providers for treatment. Well, there should not that agreement should not generally prohibit or limit the access, exchange, or use of EHI for treatment by other healthcare providers of a patient. So they shouldn't be. So I think clearly there, it's treatment for the patient. It shouldn't be discriminating between the providers. And the other piece I think I want to be clear about here is that in such instances where we would look at such agreement or contract, both the covered entity and the BA could be potentially liable under an information blocking provision. And you wonder how that could be the case. It could be the case where a BA, business associate with significant market power, was able to establish the contractual provisions that possibly prohibited or made it difficult for the covered entity's customers to exchange EHI. So that's why and they may do that because some of the healthcare providers use an EHR system that is one of the business associates' competitors. So in sum, we would look at the terms of the agreement to understand better in the market positions whether or not that once that we found that there was a discriminatory practice, why that was the case. And then educating patients about privacy and security risks for apps and third parties. Generally speaking, if you follow those 3 steps on the screen, we encourage that type of education. And we even give in the rule an example where an actor could establish a process that asks third-party developers to attest yes or no as to whether they have a privacy policy that meets certain market-led best practices. And our rule even sets out a minimum set of third-party privacy policies and practices that we think all patient-facing applications should adhere to. So I encourage you to read the rule on that matter, and also the recent blog by our Deputy National Coordinator, Steve Posnack. It was posted on March 12th on healthit.gov. And the title of that post is Power to the Patient, Our Record, Our Right, Our Choice. So let's move to the next slide. So again, one of those important elements, the knowledge standard. And this slide is a second illustration of how the Cures Act treats certain actors differently. The first illustration was that slide identifying the consequences of information blocking. So here, healthcare providers must know the practice is both unreasonable and likely to interfere with access, exchange, and use, while developers of certified health IT, HINs, and HIEs are only held to a should-know standard. And again, as with the interference, this is an important element related to information blocking. So let's move to the next slide. So the one clarification we made when it comes to required by law as compared to the proposed rule is we identified more explicitly what constitutes federal and state law, and we noted that included statutes as on the screen here, as you'll see, regulations, court orders, administrative decisions, as well as tribal law as applicable. And if what you may recall from that healthcare provider definition slide, that could be the case with providers that are operated by or under contract with the Indian Health Service or by an Indian tribe or tribal organization. So tribal laws do matter as well to covered actors. So in some respects, this action by Congress to acknowledge that there are valid reasons to restrict access, exchange, and use of EHI serves as a I'll call it a quasi-statutory exception to information blocking. And also, thus the perfect segue to our next topic, the exceptions to information blocking. So let's go to the next slide. So now I'm about to turn the presentation over to my colleague, Mark Nee, who, as mentioned earlier, serves as a senior policy analyst in the Office of Policy. Mark's going to discuss the reasonable and necessary activities that the Secretary has identified in this final rule as exceptions to the information blocking provision. Mark, I'm turning it over to you now.
All right. Well, great. Thank you, Mike, and thank you, Elise, and thank you all for joining us here today. I'm really excited to be here talking about the exceptions. You know, everyone many folks in our office have been working on information blocking and on the exceptions for a number of years now, and it's exciting to be able to roll out our final policies on a webinar like this. So first, I'm just going to kind of set the stage for the exceptions, and then I'll dig into the individual exceptions and go over the specifics of those. So as Elise mentioned, the 21st Century Cures Act defined information blocking, next slide please, defined information blocking broadly and tasked the Secretary and by delegation ONC with developing reasonable and necessary activities that will not constitute information blocking. So big picture, what are we trying to do with the exceptions? The exceptions promote patient access to their electronic health information, or EHI, as we'll call it throughout this presentation. They support interoperability and provider needs. They advance innovation and competition. And very importantly, they help address information blocking practices that we've been hearing about for years through stakeholder meetings, listening sessions, and complaints that have been submitted to us. There are three guiding principles that led the way for our drafting of the exceptions. The first is that the exceptions are limited to certain activities that we believe are important to the successful functioning of the U.S. healthcare system. The second is that each exception is intended to address a significant risk that actors will not engage in reasonable and necessary activities because of potential uncertainty or concern regarding whether they would be considered information blockers. And last, each exception is intended to be limited to the reasonable and necessary activities that they are designed to exempt. And to achieve this goal, we've structured each exception with a number of conditions or requirements that are tailored to meet our objectives. All right, so at this point you might be wondering, how do the exceptions work? So we've defined 8 exceptions that benefit actors by offering them certainty that when their practices with respect to access, exchange, or use of EHI meet the conditions of one or more exceptions, so you only need to meet one, such practices will not be considered information blocking. In many ways, our exceptions operate much like the Office of the Inspector General's anti-kickback statute safe harbors. So as Elise mentioned, and maybe Mike as well, we proposed 7 exceptions, but we ended up with 8, and we've added the content and manner exception. I'll spend a little extra time explaining the content and manner exception because it's new, so there's a lot of new information there, but also because it's really important because it acts as a funnel of sorts to some of the other exceptions, like the fees exception, the licensing exception, and the infeasibility exception. One additional very important point I want to highlight about the exceptions is that an actor's practice that does not meet the conditions of an exception will not automatically constitute information blocking. Instead, the practice would be evaluated on a case-by-case basis to determine whether information blocking has occurred. For instance, we would look at whether it rises to the level of an interference, as Mike talked about earlier, or whether the actor acted with the requisite intent or knowledge standard, again, that Mike talked about in the elements of information blocking discussion. The next slide, please. Okay, so in the final rule, we have restructured the exceptions, and we've divided the exceptions into 2 categories, as you can see on the screen. So the first category on the left-hand side of the screen are exceptions that involve not fulfilling requests to access, exchange, or use EHI. And the second category on the right-hand side of your screen are exceptions that involve procedures for fulfilling requests to access, exchange, or use EHI. So the difference is, on the left-hand side, those exceptions, if an actor met all the conditions, they would not need to provide access, exchange, or use to the EHI. However, on the right-hand side, if you met all the conditions of those exceptions, you would still have to provide access, exchange, or use of EHI, but under the procedures that we lay out. To satisfy any exception, the actor's practice or conduct, same thing that we're talking about here, must meet all conditions of the exception at all relevant times. I'd also like to note that we've made many changes throughout the rule to address comments we received about enhancing transparency and clarity in the rule. One change that we've made is we've changed the titles of the exceptions to questions for additional clarity. And we've also added introductory text with each exception to clearly frame the requirements of each exception. This new structure, we believe, will enhance transparency and help the regulated community in working through the exceptions. I also want to note at this point that, as you know, from looking at probably at the length of the final regulations, there's a lot in there, and there's a lot about the exceptions, and there's too much to cover in this presentation. So I encourage you to look at the regulation itself. But I am going to focus on kind of the highlights, and I'm going to explain our objectives and goals with each exception. the requirements for satisfying each exception. I'm going to go over certain conditions in the exceptions and also focus on important changes and clarifications from the proposed rule to the final rule. Next slide, please. All right, so here we have the first exception. So this is preventing harm. So why is this exception necessary? Preventing harm to patients and others is a top priority of ours at ONC and must be a central theme as we advance interoperability and patient access to their records. This exception recognizes that the public interest in protecting patients and other persons against unreasonable risks of harm can justify practices that are likely to interfere with the access, exchange, or use of EHI. We've finalized this exception largely as proposed. There were a lot of supportive comments about this exception, but we've modified it a bit for clarity and to better align with the HIPAA rules. One point I would like to highlight about this exception is that under the exception, an actor must hold a reasonable belief that the practice will substantially reduce a risk of harm. In most cases, the harm we're talking about must be to the life or physical safety of the patient or another person, but in some circumstances, the harm may be any type of harm that would be recognized as grounds to deny an individual or their personal representative access to the information under the HIPAA privacy rule. Next slide, please. All right, the second exception we're going to talk about is the privacy exception. So why is this exception necessary? There are many situations when protecting the privacy of EHI should override the need to share the EHI. This exception recognizes that if an actor is permitted to provide access, exchange, or use of EHI under an existing privacy law, then the actor should provide that kind of access, exchange, or use. But an actor should not be required to use or disclose EHI in a way that's prohibited under a state or federal privacy law, such as HIPAA. One point I do want to emphasize is that actors will not be required to provide access, exchange, or use of EHI in a manner that is not permitted under the HIPAA privacy rule. And this is in line with our attempt throughout the regulation to align our policies with HIPAA as much as possible. I want to note that we received some privacy-related comments about business associate agreements and protecting the privacy of EHI in relation to third-party apps. Mike already talked about those within the context of the interference discussion, and as he said, I think it'd be great for you all to take a look and read through those discussions. All right, now I'm going to talk a bit about the requirements for this exception. As you can see on the screen, to satisfy this exception, an actor's privacy protective practice must meet at least one of 4 sub-exceptions. So the first is a precondition not satisfied. So under this sub-exception, if an actor is required by state or federal law to satisfy a precondition, so that would be something like a consent or authorization, prior to providing access, exchange, or use of EHI, the actor may choose not to provide access, exchange, or use of EHI if the precondition has not been satisfied under certain circumstances. The second sub-exception has to do with health IT developers of certified health IT not covered by HIPAA. So our goal with this sub-exception is to ensure that health IT developers of certified health IT who are not covered by HIPAA are treated in a similar manner to those that are covered by HIPAA. And under this sub-exception, if an actor is a health IT developer of certified health IT who is not required to comply with the HIPAA privacy rule, the actor may choose to interfere with the access, exchange, or use of EHI for a privacy protective purpose if certain conditions are met. The third sub-exception has to do with a denial of an individual's request for their EHI consistent with HIPAA. So under this sub-exception, an actor that is covered as a covered entity or a business associate may deny an individual's request for access to his or her EHI in the circumstances provided under the provisions in 45 CFR 164, 524A1 and 2. So that one's pretty straightforward and aligns with HIPAA. And last, the fourth sub-exception has to do with respecting an individual's request not to share information. So under this sub-exception, an actor may choose not to provide access, exchange, or use of an individual's EHI if doing so fulfills the wishes of the individual, provided certain conditions are met. One change that I would like to highlight from the proposed rule to the final rule is that in the proposed rule, with regard to consent or authorization, we said that when an individual consent or authorization is a precondition to providing access, exchange, or use of EHI, an actor would need to do all things reasonably necessary within its control to provide the individual with a meaningful opportunity to provide the consent or authorization. In the final rule, we revised this requirement so that an actor must have used reasonable efforts within its control to provide the individual with a consent or authorization form that satisfies all applicable requirements, or have provided other reasonable assistance with respect to the deficiencies. So what are we doing here? In effect, this places more of an obligation on the party requesting the EHI and the individual to attempt to satisfy the precondition by providing consent or authorization. And this change was necessary because we realized that the proposed language might place too high of a burden on actors. All right, next slide, please. All right, the next exception is the security exception. So why is this exception necessary? Actors should not be deterred from implementing security measures or engaging in other activities that safeguard the confidentiality, integrity, and availability of EHI. We at ONC understand the significance and the overwhelming benefits of those types of practices, and this exception is intended to cover all legitimate security practices by actors, but we do not prescribe a maximum level of security, and we don't dictate a one-size-fits-all approach. The exception does not apply to all practices that purport to secure EHI, but instead it's only available when the actor's security-based practice satisfies the conditions of this exception. As you can see on the screen here, there's some threshold conditions, which I'll talk about, as well as the requirement to implement a qualifying organizational security policy or to implement a qualifying security determination. So the threshold conditions are pretty straightforward. The practice must be directly related to safeguarding the confidentiality, integrity, and availability of EHI. The practice must be tailored to the specific security risk, and the practice must be implemented in a consistent and non-discriminatory manner, which is a theme throughout the exceptions and throughout the information blocking policies we finalized. Next slide, please. All right, moving along, the next exception is the infeasibility exception. So this exception is necessary because sometimes there are legitimate practical challenges that prevent an actor from complying with requests for access, exchange, or use of EHI. We understand that things happen, and this exception accounts for those types of situations. For instance, an actor may not have or may be unable to obtain the requisite technological capabilities, the legal rights, or other means necessary to enable access, exchange, or use. So I want to talk about three changes from the proposed rule to the final rule in this exception. So first, we've restructured the exception so that the practice must meet one of the following conditions, as you can see on the screen in that yellow box. So the first is uncontrollable events. And for those of you familiar with contract law, this condition is essentially a force majeure clause. This condition addresses situations when an actor can't fulfill a request for access, exchange, or use of EHI because of events like a natural or human-made disaster, a public health emergency, public safety incident, war, terrorist attack, civil insurrection, strike, or other labor unrest, and so on. The second condition I'd like to talk about is segmentation. So we have established this condition in response to great recommendations we received from commenters. And this condition applies when an actor cannot fulfill the request for access, exchange, or use of EHI because the actor cannot unambiguously segment the requested EHI. The third condition is infeasibility under the circumstances. So this condition was included in the proposed rule, but the context is a little bit different given how we've restructured the exception and how we've added the two conditions I just talked about with uncontrollable events and segmentation. So this condition applies when an actor demonstrates through a contemporaneous written record or other documentation its consistent and non-discriminatory consideration of certain factors that led to its determination that complying with the request would be infeasible under the circumstances. All right, so those are kind of the threshold conditions in this exception, but I want to talk about a few other points before I move on. So as you may recall in the proposed rule, we included within the proposed infeasibility exception a requirement that if an actor claimed infeasibility under the exception, the actor would still need to work with the requesting party to identify and provide a reasonable alternative means of accessing, exchanging, or using EHI as applicable. We've removed the reasonable alternative requirement from this exception, but essentially repurposed it within the new content and manner exception, which I'll talk about more when I get to that exception. The content and manner exception improves on the reasonable alternative requirements in the proposed rule by clarifying actors' obligations for providing access, exchange, or use of EHI in all situations. It also creates actionable technical procedures and aligns the requirement for providing an alternative with the fees exception and the licensing exception. Last, I'd like to talk about the response condition within this exception. So under this exception, an actor must provide a written response to the requester within 10 business days of receipt of the request with the reason why the request is infeasible, as you can see in the blue box at the bottom left of your screen. And I just want to note that this is a less stringent requirement than proposed, which we believe will lessen the burden on actors as well. All right, next slide, please. Okay, so this is the health IT performance exception that we're going to talk about. This is the last exception within the first bucket of exceptions that have to do with not providing access, exchange, or use of EHI in certain circumstances. So why is this exception necessary? Sometimes actors should be able to temporarily take down a system or degrade the health IT to improve the performance of the overall health IT. And this exception acknowledges that that's okay under certain circumstances as long as certain conditions are met. So let's talk about the conditions for a minute. The first has to do with maintenance and improvements, as you can see in the yellow box on your screen. So under this condition, the practice must be implemented for a period of time no longer than necessary to achieve the maintenance or improvements. It must be implemented in a consistent and non-discriminatory manner and must meet certain requirements if the unavailability or degradation is initiated by a health IT developer of certified health IT, an HIE, or an HIN. And so under this provision, I do want to note that if the unavailability or degradation is planned, it must be consistent with existing service level agreements. If the unavailability or degradation is unplanned, it must be either consistent with existing service level agreements or it must be agreed to by the individual or entity being supplied the health IT. The second condition I'd like to talk about here in the blue box on your screen has to do with the assured level of performance. As Mike mentioned, or in real life, this is throttling or metering. So an actor may take action against a third-party app that is negatively impacting the health IT's performance, provided that the practice is for a period of time no longer than necessary to resolve any negative impacts. It's implemented in a consistent and non-discriminatory manner, and it's consistent with existing service level agreements when applicable. Last, I want to talk about the dark blue box on the bottom left of your screen. So if the unavailability is in response to a risk of harm or a security risk, the actor must only comply with the preventing harm or the security exception as applicable. All right, next slide, please. Okay, so now we've ventured over into the second bucket of exceptions, and these are the ones that you would still need to provide access, exchange, or use of EHI, but under the procedures that we lay out in the exceptions. So here we have the new content and manner exception, or put another way, the what and how exception. So why is this exception necessary? As I mentioned, we did not propose this exception, but it is related to our proposals regarding the electronic health information definition and the reasonable alternative means for accessing, exchanging, or using EHI that was part of the infeasibility exception in the proposed rule. So this new exception addresses two groups of comments. First, comments about the what, or for instance, what do I need to provide in response to a request for access, exchange, or use of EHI? We received comments that expressed concern regarding the breadth of the proposed electronic health information definition, and also comments that requested flexibility in the implementation of the information blocking provision. The second group of comments are the how comments, or how do I need to respond to a request in order to fulfill the request for access, exchange, or use of EHI. And so we heard from commenters that they wanted clarification regarding our proposal about a reasonable alternative. And more broadly, they requested clarification about when it would be okay to not fulfill a request in the manner requested. So our goal with this exception is really to provide clarity and flexibility to actors concerning the required content, the scope of the EHI, and the manner in which the actor may fulfill the request. This exception is really important, as I mentioned before, because it works as a funnel of sorts for other exceptions, particularly the fees, licensing, and infeasibility exceptions. And what I mean by that is that working through the content and manner exception will help the regulated community or the actors gauge whether those other exceptions really even come into play or should be considered. For instance, in many cases, the fees and licensing exceptions will only be used within the context of the content and manner exception because, as I'll discuss in the next couple of slides, the conditions of those exceptions do not apply if the actor is fulfilling a request in a manner requested. All right, next slide, please. Okay, so here we have the content condition, or the what of the content and manner condition. So this condition establishes the content, the scope of EHI an actor must provide in response to a request for access, exchange, or use of EHI in order to satisfy this exception. So let's break it up into the two parts you see on the screen. So up to 24 months after the publication date of the final rule, an actor must respond to a request to access, exchange, or use EHI with, at a minimum, the EHI identified by the data elements represented in the US CDI standard. So as Mike talked about, the information blocking compliance date is 6 months after the publication date of the final rule. So what this provision here is saying is that in addition to the 6-month compliance delay, actors will have an additional 18 months during which they only must provide access, exchange, or use of EHI identified by the data elements represented in the US CDI. So this period of 24 months from publication of the rule will provide actors with time to practice and prepare for the sharing of all EHI and to sunset any non-compliant technology. And also, we believe, creates a clear and actionable timeline for when all EHI must be available for access, exchange, and use. As discussed earlier in this presentation, this time frame aligns with the change we've made in the information blocking definition in section 171.103, and we've included this time frame in this exception as well as in the information blocking definition so that our policies are clear and consistent and there's no confusion about this time frame. So looking at number 2 on your screen, on and after 24 months after the publication date of the final rule, the actor must respond to a request to access, exchange, or use EHI with EHI as defined in section 171.102. So what this provision is saying is that after the 24 months from publication of the rule, actors must fulfill a request for access, exchange, or use of EHI with all the EHI they have, or all the EHI, excuse me, which, as Mike discussed, is EPHI to the extent that the EPHI would be included in a designated record set. All right, next slide, please. Okay, so now we're on to the manner condition, or the how. So there's really 2 parts to this condition with separate rules for each. There's fulfilling the request in any manner requested, and then there's also fulfilling the request in an alternative manner. So let's first talk about fulfilling a request in any manner requested. An actor must fulfill a request in any manner requested unless the actor is technically unable to fulfill the request in a manner requested or cannot reach agreeable terms with the requester to fulfill the request. So we structured this exception in this way because we believe actors should first and foremost attempt to fulfill a request for access, exchange, or use of EHI in the manner requested. This principle is really central to our information blocking policies. It was part of the infeasibility exception, and it also supports EHI being made available to patients, providers, and others where and when it's needed, which is an overarching theme throughout the rule. We understand, however, that there may be instances when an actor should not be required to respond in the manner requested, and this condition addresses those types of situations. All right, so let's dig into the first part of the manner condition. So an actor must fulfill a request in any manner requested unless the actor is technically unable to fulfill the request in the manner requested. And so this means that an actor cannot fulfill a request to access, exchange, or use EHI due to a technical limitation. This standard sets a pretty high bar and would not be met if an actor is technically able to fulfill the request but chooses not to do so in the manner requested due to, for instance, not having all the necessary rights, cost, burden, or other types of justifications. Those justifications may very well be legitimate, but they're probably going to be covered under other exceptions such as the infeasibility exception, fees, and licensing exceptions. Number 2 on your screen is that cannot reach agreeable terms with the requester to fulfill the request. And then the bullet underneath there is that if an actor fulfills a request in any manner requested, the actor is not required to comply with the fees or licensing exception. So the way this works is that if a requester requests access, exchange, or use of EHI in a certain manner, the responding actor will have the opportunity in every situation to reach agreeable terms that are not limited by the fees or licensing exceptions. The actor would be able to attempt to negotiate agreements in a manner requested with whatever terms the actor chooses and at the market rate, which we believe supports innovation and competition. But if the actor can't reach agreeable terms with the requester, then the actor can fulfill the request in an alternative manner, which I'm going to talk about momentarily. So here's an example. For instance, if an actor cannot reach agreeable terms with the requester regarding a license for interoperability elements that constitute proprietary intellectual property that are necessary for access, exchange, or use of EHI, the actor would not be required to license its intellectual property in order to satisfy the exception. Instead, in that type of situation, the actor could just drop down to the alternative manner provision. This approach, we believe, provides flexibility for actors to satisfy the exception even if they can't reach agreeable terms. It also allows actors to first attempt to reach agreeable terms as they would normally. And in this way, the exception really, we try to maintain the status quo and allow the market to work. And we believe in many cases the market will work and actors will not even need to consider this exception. Next slide, please. Okay, so here we'll talk about the second part of the manner condition, the alternative manner. So if an actor is technically unable to fulfill the request in the manner requested or cannot reach agreeable terms, then the actor may fulfill the request in an alternative manner. If an actor responds in an alternative manner, the actor must fulfill the request without unnecessary delay in the order I'm going to talk about now, only proceeding to the next consecutive paragraph if technically unable to fulfill the request in that manner. So let's look at the different manners in the order of priority first. First line, we have certified technology. So we say using technology certified under our program. So this manner of response is given precedence because it advances a certified standards-based approach that supports the promoting interoperability programs administered by CMS, other federal and state programs that use certified health IT, and other federal departments such as DoD and VA. Also, the certification criteria under our program include robust oversight, including technical and interoperability requirements, in-the-field surveillance expectations, and cost transparency, and other disclosure requirements. So looking at these factors, we believe that certified tech should be the alternative manner that is essentially first in line here. So if you're technically unable to meet that first line, which is certified technology, then you would be able to bump down to the standards-based technology, number 2 on your screen. And this manner advances interoperability through standards-based exchange, even if the standard is not certified under the program. So that's the second line. If you are technically unable to meet the standard-based technology described here, using a content standard, a content and transport standard specified by the requester and published by the federal government or a standards developing organization accredited by ANSI, then you would move down to the alternative machine readable format, or kind of the catch-all here. What we say is using an alternative machine readable format, including the means to interpret the EHI agreed upon with the requester. So this option is for actors who are not technically able to fulfill the request using certified or standards-based technology, but still want to be responsive to the requester and seek coverage under this exception. So some examples would be CSV, public domain standards, public advisory standards, and so on. 2 points I want to highlight on this one is first that we say that there needs to be the means to interpret the EHI. So the goal with that language is that this requirement is to ensure if an actor fulfills a request for access, exchange, or use of EHI using an alternative machine readable format, the EHI provided through that format would actually be usable by the requester. Obviously, that's important. Second, the alternative machine readable format must be agreed upon with the requester, and this ensures that even if the actor is technically unable to meet the requirements for the higher priority manners in 1 and 2, the actor is still providing the requester the opportunity to access, exchange, or use EHI in a manner that's amenable to the requester. 2 additional points I want to highlight here are without unnecessary delay. So we include this language that an actor must fulfill the request without unnecessary delay in order to make clear that actors seeking coverage under this exception by responding in an alternative manner will be held to the same timeliness considerations as actors responding in a manner requested. And Mike talked about earlier the various types of interferences, and it's important to note that unnecessary delay could be considered an interference. The second point has to do with, and it's really an important one, has to do with fees and licensing. So in contrast to the requirements I just talked about for responding in a manner requested, any fees charged or licenses granted by the actor in relation to fulfilling a request for access, exchange, or use of EHI in an alternative manner must satisfy the fees exception and the licensing exception. And we believe this requirement is appropriate because it's our understanding that in most cases, licensing certified technology or standards-based technology will involve open standards. Next slide, please. Okay, so here we have the fees exception. We're down to the last 2, so don't worry, we're almost there. The fees exception. So why is this exception necessary? We believe that actors should be able to charge fees related to the development of technologies and the provision of services that enhance interoperability. But we also believe that they should not be allowed to engage in practices that constitute rent-seeking or opportunistic fees or other exclusionary practices that interfere with access, exchange, or use of EHI. And our goal with this exception is not to set any particular fees related to products or services for access, exchange, or use of EHI, but rather to allow the market to define the appropriate price for such products or services so long as certain methods are followed and certain criteria are met. So a note about this one first is that we did change the name. As you might remember, we framed the original exception in the proposed rule as an exception for recovering costs reasonably incurred, and now it's the fees exception. So we're talking about the same thing here. The change is consistent with our approach to focus on fees within the exception, which are, of course, related to costs incurred. So just a different shift there a bit. A point I want to highlight is we explained in the proposed rule, and we also reiterate in the final rule, that an actor who seeks to satisfy this exception will not be prevented from making a reasonable profit in connection with the access, exchange, or use of EHI, provided that all applicable conditions are met. And we believe this allowance is necessary to incentivize innovation and allow innovators to earn returns on their investments. Now I'm just going to go explain some, at a pretty high level, some of the conditions within this exception, but I want to emphasize that this is not an exhaustive list. So a few that I want to highlight are: the practice must meet the basis for fees condition. So some of these are that the fees an actor charges must be based on objective and verifiable criteria that are uniformly applied for all similarly situated classes of persons or entities and requests. The charges must be reasonably related to the actor's costs of providing the type of access, exchange, or use of EHI. And the charges must not be based on whether the requester is a potential competitor or an actual competitor. In this exception, we also identified certain excluded fees that would not qualify for this exception. So a couple I want to highlight here are a fee based in any part on the electronic access by an individual, the personal representative, or another person or entity designated by the individual to access the individual's EHI. So we heard from commenters overwhelming support for our proposal regarding individual access, individual electronic access. Commenters across stakeholder groups emphasized that patients have a fundamental right to access their data and should be able to access, exchange, and use their EHI at no charge. And I just want to note, as Mike said earlier, that for purposes of the fees exception, we define electronic access in this exception. I also want to note another excluded fee would be a fee to perform an export of EHI via the capability of Health IT certified at 173.15b10, the export criterion. And last, to satisfy this exception, as you can see on the very bottom of your screen in the dark blue box, an actor must comply with the assurances and or the API condition of certification as applicable. All right, so next slide, please. All right, we're finally there, the last exception, so the licensing exception. So why is this exception necessary? Sometimes a license is necessary to get the EHI out to patients, providers, and others. And this exception allows actors to protect the value of their innovations and to charge reasonable royalties in order to earn returns on their investments that they've made to develop, maintain, and update those innovations. So I'm going to talk briefly about some of the conditions within this exception. So first, you have negotiating a license conditions. So under this one, an actor must begin license negotiations with the requester within 10 business days from receipt of the request and must negotiate a license within 30 business days from receipt of the request. This, I would just want to note that this time frame was expanded from the proposed rule and provides actors with increased flexibility for negotiating a good faith license, taking into consideration potential complexity and variability associated with these types of negotiations. And we believe this is a clear timeline that will reduce a potential burden on actors. There's also a number of licensing conditions. Just a quick note overall that we've removed all references to RAND, or reasonable and non-discriminatory. That terminology was confusing to some commenters, so we finalized the rule without that term, but I do want to emphasize that we finalized the majority of the substantive conditions for the licensing of interoperability elements under this exception as proposed. And some of those conditions are the scope of rights, reasonable royalty, which just as under the fees exception would allow for reasonable profits. There's provisions for non-discriminatory terms, collateral terms, and non-disclosure agreements. Additionally, there's some other conditions as well that you can see at the bottom of your screen in the dark blue relating to the provision of interoperability elements. So with that, I've reached the end of my part of the talk, and I'm going to turn it over to Elise to take us home.
Thank you, Mark, and thank you, Mike, as well. So before we close out, we do want to spend a couple of moments talking about the complaint process. And our goal with the information blocking section of the rule and overall with all of our activities at ONC and the rule in its entirety is always to provide clarity in terms of what the expectations are so that all of the stakeholders involved are able to know what is expected of them and what their abilities are to address where something is not happening as it should. So next slide. Congress asked us as part of Section 4004 of the 21st Century Cures Act to identify a standardized process that the public could use to submit reports or claims of information blocking. We currently have on our website, as you note there in our second bullet, a health IT feedback form. And on that form, you'll see a button that you can click if you want to submit information regarding potential information blocking. That's our process for implementing at this point. We look forward to evolving as necessary over time. In addition, for additional information regarding the complaint process and how to go about that, you can check out the homepage for the rule, for the Cures rule, which is healthit.gov/Cures rule. I do want to note one component regarding claims or information we receive regarding information blocking. Next slide. In addition to asking ONC to think about and set up a process for receiving such claims or information regarding information blocking, Congress also identified that there are certain protections that apply to information ONC receives in connection to a claim or to a suggestion of information blocking. And that includes, generally, a protection from disclosure under the Freedom of Information Act. And I've included the language here, but I think it's also something that's important to note. Generally, as we think about the complaint process, again, we want to hear where something is not going right. If information blocking is occurring or there's a suggestion of possible information blocking, it's important that these rules are implemented as effectively as possible. And in order to do that, we need to know what's happening on the ground. Next slide. So for more information, so what's next? So first, let me just go back and remind folks to join us for our Health Information Technology Advisory Committee meeting, which would be on March 18th from 10 to 1. We'll be discussing information blocking and presenting to the committee itself about the provisions and the updates we've made between the proposed and the final rule. There's always an opportunity for public comment on those calls, and we encourage you to participate there. In addition, on March 19th at 2 p.m., not 3 p.m., to clarify, at 2 p.m. Eastern Standard Time, there will be our next webinar, which will focus on conditions of certification. So again, there's two main sections of the rule. The information blocking section is what we talked about today. The conditions of certification is the other large main section. There's several other provisions included in the rule, but the next webinar will focus on that large body of the conditions of certification. Things you'll expect to hear in that webinar will be around application programming interfaces and requirements that are in place for certified health IT developers in that regard, things like real-world testing as well. So please join us. We look forward to discussing those provisions with you as well. So to check out the final rule, to look at our fact sheet, to see the upcoming webinar schedule, to listen to the recorded webinars, please do check out our website. Our goal is to provide information for you to make it easier for you to identify where in the actual rule you might want to check out, read up a little bit more about. The last thing I want to mention is we will also be scheduling webinars that are focused on frequently asked questions. So those will be coming up in the future. So sign up for our listserv or just check back on our website and you'll see when those are scheduled as well. Next slide. So with that, we want to encourage you to continue to listen in, join in, read through the rule. We really are excited about having this rule out and ready for implementation. And of course, to thank you for joining us today. Thanks. Have a good day.